Alright, so today I am going to be talking about a recent submission I made, a public comment on a proposed change to the Federal Rules of Criminal Procedure, specifically on Rule 17. I'm just going to explain quickly why I did it, what I wrote, and why it matters. So Rule 17 is a rule that governs subpoenas in criminal cases or criminal cases. A subpoena is just a court order that makes someone bring evidence or to testify in court. For defendants, this could be really important as it's sometimes the only tool they have to prove their innocence. The proposed amendment would definitely make it harder to obtain any evidence from victims without giving notice, which seems fair. Like, I feel like you should give notice, but it actually could harm the defendant's ability to build a case for themselves if they're truly innocent. I chose this comment because less than 2% of federal cases actually go to trial, and most just end in plea deals, because if the defendant can't access all the evidence they need, then they just are most likely to just plead guilty, as you will get a lesser sentence most of the time, hopefully. But to me, that's a huge problem in the fairness of a trial. In my comments to this Rule 17, I listed three main points that I think that the restriction of the access to this evidence is going to slow the process down completely, especially with hospitals, which even is much slower to begin with. So it's going to slow it down or just make it impossible to access any of those medical records or any records that you may need from a victim or just in general someone to testify. Second, I would say specifically the New York City Bar Association pointed this out recently too. I think it might have been before the law has been proposed or the rule has been proposed, but basically that it could lead to unfair trials, in which I've made it clear that it would just be unfair because if they are innocent and they had one person to testify that could solve this whole thing and they weren't allowed to, that's just very unfair and can lead to wrongful convictions. And lastly, I just think that there's a different way that we could move forward. I know in Rule 16 we already have these standard, like, what evidence that's relevant and stuff like that, but truly, if we decide not to make subpoenas harder, the rules can just be modified so that defendants have a fair shot at defending themselves. They only need to show what evidence that is relevant, and the judge can throw out any unreasonable requests. And that's just leveling out the playing field. It's going to make it fair for everybody and give a fair chance to the defendants. So what it truly means is that the balance of the court system and the trials are very more towards protecting victims' privacy, which again is very understandable, but we also need to make sure that defendants have a fair shot of proving their innocence when they are. If the rules lean heavily in one direction, then the entire system is just very unfair and it suffers. But my comment basically urges the committee to just rethink the whole Rule 17 and at least modify it so it would be fair to both the victim and the defendant in the case. But lastly, I just wanted to share this public comment because people like me can still have a say in how the justice system is shaped, even if we're not in court setting precedents. But if you're interested, you can submit your own, like I said, February 16th, 2026. But thanks for watching. I'll leave the link in the description to submit your comment. But yeah.